Good morning.
Good morning. Your first case has been dismissed.
Oh, well, I've turned everything on, and we're going to have a lot of dead air.
So your first case won't show, hopefully the defendant won't show up for you.
Okay. All right, thank you. Bring me some more of these.
Okay, let me go see if I can find more.
Okay. Well, I've turned on the live feed. This is Judge Middleton here at the court in Centerville. It's Friday, feels like Friday, April 30th, 2021. Today is Civil Day. We have a number of landlord-tenant cases and civil matters, probably have a dozen or more scheduled for this morning. Our first matter is set for 9 a.m. and it has resulted in a dismissal. We have another case that we will be bringing in, so you should be ready to start here momentarily. Good morning, Christine.
Good morning.
I'm going to bring Bettina in. Good morning, Bettina.
Good morning.
Did you miss me?
I did. How are you?
Like a toothache. Yeah, you had some time off here like I did. So let me get situated here and we'll begin. Mr. Bukowski's in the waiting room, Christine.
Okay.
Let me turn things on here. There's Deb. I'm not sure who this is. Oh, that's Miss Steinman. Okay, looks like we're ready to go. We're going to call our first case. This is entitled James and Deborah Steinman versus Stephen and Sonia Bukowski. Attorney Christine Yancey is here for the plaintiff. Deb Steinman is on the feed. Also, Stephen Bukowski is there. Mr. Bukowski, is Sonia with you?
She's actually still sleeping.
All right, but she's there.
I don't know if she had to be here or if it could just be me, because...
Well, she's a named party, but let's talk about this. Also, Bettina Emery is here from Keystone. This is a termination of tenancy. It's a land contract forfeiture, so it's a little different. There's a land contract between the Bukowskis and the Steinmans that the Steinmans say is in arrears. The law requires, Mr. Bukowski, that I advise you of these rights. I'm sorry she's sleeping through this proceeding, but I'm not going to wake her up to do it. The law says that as a defendant in a landlord-tenant proceeding, including non-payment of rent and others, including a land contract forfeiture. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, Keystone, could help you with the rent. But this is not that kind of a case. Keystone doesn't provide assistance for land contract forfeiture cases. If the plaintiff is agreeable, the Citizen Mediation Services may be available as a possible source of case resolution. If the parties are interested in that, the court can set it up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a hearing. However, if the judge does not find in your favor, the original judgment would stand. This is the initial hearing. The law requires, Ms. Steinman, that I set this for a second hearing. In this particular type of hearing, it has to be at least 7 days away. So let's see what we can accomplish at this point, though. Ms. Yancey, the arrearage is alleged to be $4,000 plus other damages plus costs, a total of $7,323. Is that still accurate?
It is, Your Honor, and just for clarification, the other damages are for real estate taxes that have been delinquent. My clients have been trying to get those caught up so that they don't have to face the threat of foreclosure from the county, but there's still some amounts that are going to be due here again, so they're doing the best they can to try to keep it current.
All right. Mr. Bukowski, what's your position here?
Okay. Well, I had all the money when I was waiting on money in the beginning of 2020. All my taxes, everything. I lost my job. I lost everything. I was waiting on taxes to get everything squared away. Now, first off, I never actually talked to them about it. It was more my mom that was discussing it with them.
Well, let me ask this. Do you intend to try to catch up on this, or do you intend to move?
I was actually, me personally, I'm intending on moving, but I'm not the first one who signed the contract. The first one who signed the contract would be my mother.
And your mother is Sonia?
No, Patricia Palmer. She's the first one to sign the contract. I don't know if you have a copy of her contract, but it says clearly on the last page in my contract where she signed. And she signed right on the line, and I signed off of the line. Or underneath it.
Yes. She's not a party to this action. Christine, what's the story regarding that?
Your Honor, she signed on it, but if you look at the land contract, it's just between Stephen and Sonia. I'm not sure, I wasn't a party to that. She did sign on there, but she is not in the opening paragraph with regard to the contract being between the Steinmans and the Bukowskis.
They made her sign first. They told her I could not sign that contract without her signing first.
All right, well, that's an issue that's open here.
You know, I can certainly add her, but I was going by what the contract said in terms of its body.
I mean, that's not, I mean,
Well,
that's not.
all right, well, here's what I was asking. If you're going to move, it might be simpler to just move, quit claim the property back to the Steinmans and go on from there.
Well, that's kind of the plan. I was kind of waiting for the court date, not to interrupt, I'm sorry. But I was kind of waiting for today so I could have my side to discuss things, because whenever I go by there, I can never seem to catch them around. So, and I didn't
Well, the
think.
law requires that I set a second hearing, and it has to be at least 7 days from today.
Now,
I wanted to keep the house. And
All right.
my
just
mom
a minute.
says she wants to keep the house and she's willing to pay.
I guess I would ask, is Miss Palmer there right now?
Yes. May she speak?
Yeah, just a minute. Christine, this is a little convoluted because she's signed under land contract purchaser. And Sonia and Stephen then signed as on the next line. So if you evict Sonia and Stephen, she has standing to say, well, I'm on the contract and I wasn't given notice. So perhaps we better add her.
Yeah, I can add her. I just didn't because she's not in the body of the contract itself. It's just regarded the Bukowskis.
Well, that's true. However,
I'm happy to add her, Your Honor.
it would be simpler to add her now than to go through it and then she says, well, I have standing, you can't. And perhaps it's a solution to this. If the Bukowskis wish to leave and Ms. Palmer wishes to take over the contract, maybe something can be accomplished in that regard. Does Ms. Palmer live there?
Yes.
So you and Sonia and Patricia Palmer all live there?
Yes.
And your intention is for you and Sonia to leave, and your mother would then take the contract over?
Correct.
All right, Christine, 7 days from today is May 7th. That may be a little soon. And we have May 10th, Monday, and then May 14th. Let's see what that is.
Your Honor, what time would May 7th be?
Well, in the afternoon, I have a judge conference in the morning, but I'm thinking you got a adder and server. I'm not sure we can do that in 7 days.
I know I can on the 7th. I'm working a United Way event in the afternoon.
How about May 14th at 2?
That works.
indicate you have 7 days to add Patricia Palmer as a party.
Yeah, but Patricia's taking over as owner because the Bukowskis are leaving. They're adding her to the contract, so now she's the person.
I understand that's what you wish to happen, and maybe it will, I'm not sure. Christine, you can discuss that with your clients and see if they're interested in having a voluntarily vacate the premises by the Bukowskis and set up a new contract. But one issue, Ms. Palmer, it isn't like, well, I'm just going to take over the contract. There's the issue of the unpaid taxes. The Steinmans have been paying the taxes to keep the property from being foreclosed on. And so there is, and not to mention the fact that the land contract payments weren't made. They claim that $7,000+ is owed. And I think what you're envisioning is she'll just forgive all that and start over with you on a new contract. I'm not sure that's what they're interested in.
No,
So,
her interest is catching it up.
Patricia would catch it up?
Can I speak?
May she speak right now?
And Your Honor, I can go ahead and get her amended. The concern obviously that we have, if she's been living there that whole time, why haven't the payments been made if she was there?
Well, I don't know the answer to that, but I encourage you guys to talk between now and the 14th.
I would be willing to talk.
All right. In fact, Christine, would there be an advantage to putting you guys in a breakout room right now to talk while everybody is here now?
Yeah.
All right. I can just go ahead with our other business. Mr. Bush has got plenty for me to do. And Bettina's going to save the day for a lot of people here. I'm going to put you guys in a breakout room and then you can just hang up when you're done. But everybody's here, including Ms. Palmer. At least you can discuss it. But for purposes of the record, matters continue to May 14th at 2 o'clock. And the plaintiff is going to add Patricia Palmer as a party.
Okay.
All right, I'll see you on the 14th. Good morning, John.
Hello, Judge.
Got a lot of cases today, and that's, I guess, good. Chris is in the waiting room. Let me bring her in. Bettina is here with us.
Hello.
These are mostly non-payment of rent cases. So let's see what we got. Let's bring in Ms. Corpening. We have 4 of your cases. I'm going to bring in some telephone number, which might be Angus. Good morning, can you hear me?
Yeah, I can hear you.
What's your name?
Tristan, Angus.
All right. Do you have the ability to do video?
I do not. I don't have a good signal at my workplace. It's very, very crappy.
Okay. This is Judge Middleton. I'm here at the court in Centerville. This is the time and date for a landlord-tenant proceeding in the matter of Memory Lane's Mobile Home Park versus Tristan, Angus, and any other occupants at Lot 211. The manager, Chris Corpening, is here. Mr. John Bush is here on behalf of the park. And Bettina Emery, our Keystone Hara advocate, is also connected on the feed. Mr. Angus, we are on YouTube and we're on Zoom, and this is being recorded. This is a demand for non-payment of rent. They allege that your rent is $855 per month and it's substantially in arrears, which we'll get to here in a minute. The law requires that I advise you of your rights as a defendant in a landlord-tenant proceeding. I do this a lot. I'm going to do it about 8 or 12 times today, but as a defendant in a landlord-tenant proceeding, including non-payment of rent, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case Keystone, or other federal or state program may be able to assist you with payment or some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. Summons and complaint are sufficient. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable, the court can facilitate that mediation. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. As I indicated, this is filed as a demand for non-payment of rent. Rent's $8.55 per month. There are some other expenses in there also. Ms. Corpening, what's the current arrearage?
Your Honor, it's $3,704.05.
Through April?
Yes, sir.
So we'd add another $8.55 for May?
That is correct.
3704.05 plus 855 is 4,559.05. As I indicated, our HARA advocate is here from Keystone. Ms. Emery, have you had any contact with this party?
No, sir, I have not.
The law requires that I adjourn this matter. In March, they changed the rules again, and in non-payment of rent cases, I have to grant a 30-day adjournment to allow Keystone time to process the paperwork and see if they're eligible. Mr. Angus, what's your position here?
To be honest, I just recently got out of a relationship that was very toxic. She ended up using a lot of my money, and that's why I haven't been able to pay rent. I was choosing to keep her happy over paying rent, kind of screwing myself, but now I'm no longer in that relationship. I actually, last night, I don't know if they've been to the office yet this morning, but last night I dropped off a check for $1,000 and a note about it. I was willing to give them $1,000 a week because my job, I make about $1,200, $1,300 a week, and I left a note saying I'd be willing to be able to pay $1,000 a week until I'm out of the debt. So it should only take, and then including that check that I dropped off this morning or last night, and I don't know if they got that or if she's aware of that yet, but that's all right. Well, I really don't have any excuse.
Okay, well, you might be eligible for some assistance from Keystone. And I would encourage, you can certainly pay your rent yourself if you get a tax refund or a stimulus check or a bonus from work.
Yeah, and I was also waiting on the stimulus check and my tax refund to help this, but they've yet to come in them. I don't know what's going on with those. They're taking longer than normal, but I'm, yeah, so go ahead. Sorry, I didn't mean to interrupt you.
Well, the law requires that I set this for at least a 30-day adjournment. John, we're a little squinched here because Monday, May 31st would be the 30th day. That's Memorial Day. The courthouse is closed. Friday, the 4th, I won't be here.
I'm going to be going also, Your Honor.
You going to Mackinac Island?
No, I think hoping on Michigan.
All right. I won't be here that day, but I'll be here on Monday the 7th. To Monday, June 7. Let me look at the calendar again and see what times are available.
Well, certainly, if he can pick up $1,000 a week or whatever, he may be close to being paid off.
He's gonna be in great shape, but he may be eligible for some help.
To be honest, I mean, I'm more than, like, don't get me wrong, like, I would like help, but I did the damage myself. I'm able to pay it off. I'm just need to start. I started, you know what I mean? I just need to start it somewhere.
All right. Well, I'm gonna continue this to Monday, June 7th at 1:15. If you pay everything off, it's $4,559 through May. Then we don't need to have a hearing. If
Okay.
you don't, now nothing prohibits you from contacting Keystone and see if you're eligible for some assistance. I encourage you to do that, but you don't have to. If you get a $3,000 tax refund and a couple of good weeks at work, you're caught up. And you just start over again on the 1st of May. But I will recommend defendant to contact Keystone. All right, stay in contact with Miss Corpening. She does a good job of running the show over there, and let her know what your intentions are. She'll probably find that $1,000 check, which shows good faith in your part, which reduces the $4,500 to $3,500. You got a plan to get this resolved, and if you do, then we'll be in good shape. If you don't, we'll have further hearing on June 7th at 1:15.
Sorry, I didn't mean to interrupt you. You said Miss Courtney's there, correct?
Yes,
And she can hear me and everything?
correct.
All right. This is directed towards her. I've also got new skirting on the way to repair the side skirt that's fucked up. Excuse my language. That's damaged and everything. So they left a note about that too. That I'm trying to get that fixed. It's just taking a few weeks to get in.
Your Honor, I did get the letter and the $1,000 check, and I am willing to work with Mr. Angus.
All right, very good. Where are you working?
I'm looking at Dutchman Plant 815.
All right, those places are booming right now. All right, good for you,
Yeah.
Mr. Angus. If this is resolved, you don't need to be here, and Christine will let you know that. If it isn't resolved, I'll see you June 7th at 1:15.
All right. Thank you, sir.
You're good to go.
All right. Thank you.
All
Have a good
right.
day.
Thank you.
Remove Mr. Angus from, now, in the old days, you would have to take a half a day off to work and drive up here. Although we only did it by telephone, we were able to do it from work. I'm going to bring in the next three people, which is Donald Rhodes, Nicole Roy, and Heather somebody. Heather Schrock, I believe. We're just pretty close to on time, a few minutes behind. Good morning, Mr. Rhodes. Can you hear me? Miss Roy, can you hear me?
Yes.
And Miss Schrock, can you hear me?
Yes.
Do you have the ability to do video?
Let me see.
There you go. Is Mr. Gilmore with you?
Jerry, get on your thing.
Well, he can be on your phone there with you.
Yeah,
At any
mine-
rate, there are two cases we're going to deal with. Memory Lane's Mobile Home Park versus Donald Rhodes and Nicole Roy, and Memory Lane Mobile Home Park versus Heather Schrock and Gary Gilmore. I'm going to advise all of you right now of your rights in a landlord-tenant proceeding. We'll kill two birds with one stone here. So if everyone listened carefully, as a defendant in a landlord-tenant proceeding, including non-payment of rent, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which these are, the Michigan Department of Health and Human Services, in our case Keystone, or other federal or state agency may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. Summons and complaint are sufficient, and you've already received the summons and complaint. If the plaintiff is agreeable, the Citizens Mediation Services may be available as a possible source of case resolution. Parties are agreeable, the court can facilitate that mediation and help set it up. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you're waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. If the judge does not find in your favor, the original judgment would stand. Now the first case is Rhodes and Roy, that's set for 9:20, and Schrock and Gilmore is 9:40. So we'll do Mr. Rhodes and Ms. Roy first. This is a non-payment of rent case. Rent is $8.55 per month. Last paid, according to this, in November. Ms. Corpening, what's the status here?
As of April, Your Honor, was $4,581
And if we had $8.55 per May?
for May. That's correct.
$4,581 plus $8.55 equals $5,436.
That's correct.
That's not including costs.
Correct.
Now, Bettina, have you had any contact with these folks?
Yes, sir, I have. They have submitted their application online, and they are currently in processing.
Very good. That's new, the application online. The arrearage is pretty substantial, but we got a large infusion of emergency money to help people pay the rent. So you've already started that process.
Yeah.
Let me make some notes here. Mr. Rhodes and Ms. Roy, there's a good chance that they're going to pay all or at least a substantial portion of your rent. You may be responsible for some other things, but I don't know if you have a tax refund or that sort of thing coming up. The law requires that I continue this for 30 days. So I'm going to continue for a second hearing for June 7th. At 1:25, but we'll say 1:20. I want you to stay in contact with Keystone and stay in contact with your manager. Are you both still in the premises?
Yes, sir.
Yes, sir.
Mr. Rhodes, are you working someplace?
Yes, sir.
Where are you at?
I work at Revel Production.
What's it called?
Revel.
All right,
It's
very
for
good.
Patrick.
And Miss Roy, are you working?
No, sir.
This is called eviction diversion. The point is to try to help people from being put out on the street. The other part of the program is it helps landlords like Memory Lane Mobile Home Park get their rent paid. They've got expenses of their own. So this is a lot of money, $5,500 plus costs, but I'm confident there's going to be some help here. So this is continued to June 7th at 1:20 p.m. I'll see you at that time. Do you have any questions?
No, sir.
All right, stay in contact with Keystone and stay in contact with your manager. I'll see you. Now, if it's all resolved, nobody needs to be here. There could be a conditional order of dismissal. If it's not resolved, I'll see you on June 7th at 1:20. Okay?
Thank you.
Thank you.
All right, you're good to go. Good luck to you both. Mr. Gilmore, you've joined on the feed here. Good morning, sir.
Good morning.
And Heather is still with, are you in the same house?
Yeah, she just went to the bedroom for the phone charger.
All right, yeah, if you get too close, we get feedback. Ms. Corpening, what's the arrearage here?
As of April, $5,715. The rent is $745.
5715 plus 745 is through May. 6460. You guys agree with that?
Yes.
Have you been in contact with Keystone?
I did the thing when they came out here. I filled out something, and then I don't know what Jerry did.
All right, Bettina, what can you tell us about this?
They have submitted an application online, and we are currently awaiting documents from the landlord. And then once we receive that, they'll be sent over for processing.
All right. When the new law took effect last summer, they required all the judges to have a second hearing, 7 days away from the first hearing. The problem was that didn't give Keystone and the other housing advocates enough time to do all the paperwork they needed to do to get the money flowing. It often took 2 weeks or more. So in March, they changed the rules in non-payment of rent cases, and we have to continue them for 30 days. Now, in the meantime, there's also a CDC eviction moratorium on non-payment of rent cases until June 30th. So we're adjourning at 30 days, but as a practical matter, the landlord can't pursue an eviction within that time period anyway. So Ms. Schrock, you've apparently completed the application, and they're going to work on that. Now, as I said in the last case, they may pay all or some of it. You may be required to pay the balance. Mr. Gilmore, are you working somewhere?
I got unemployment.
All right. How about you, Heather?
I work at Adapt.
How'd you get so behind? They say you haven't paid any rent since September.
I moved out the beginning of summertime, and I just recently moved back within about the last 2 months. So I didn't pay anything when I had moved out.
I couldn't pay anything. Although I was under the impression that my rent was paid through September until the end of January. That's what I was told.
Well, we'll sort that out, but I don't think so. Where are you on unemployment from?
Where am I getting unemployment from?
Yeah.
Unemployment agency?
Yeah, where did you last work?
Oh, Speedway. I guess that right at
Well,
the
there's all kinds of jobs all over the place. But
I've been putting in my job applications and stuff now that everything's starting to open back up.
All right, well, hopefully you get some emergency help. There's a lot of rent due, $64.60.
This is
Obviously,
heavy.
you don't want to move, but Memory Lanes needs to get their money. So we're gonna continue this to June 7th at 1:25. Now, as I told the last people, if the rent is paid, then we don't need to have a hearing. If it isn't paid, we'll have further hearing at that time on June 7th. Heather, when did you move back in?
I think the beginning,
February, maybe?
yeah, but the end of February, early March.
It was the end of February.
All right. Well, that doubles your income, so, all right. Do you have any questions? Follow through with Keystone, keep in contact with your manager, and I will see you on June 7th at 1:25.
Well, my understanding, because I filled out the diversion thing, and I got word from them, so I guess they're just waiting on some paperwork.
That's the way I understand it, so let's hope that comes through and pays all or a lot of your rent. All right, do you have any questions?
No.
No.
Okay, you're good to go.
Thank you.
Remove Mr. Remove Heather. Our next case isn't set until 9:50. And we'll stay on the feed here. This is Lee and Sandra Bell. I've always known him as Hank Bell. They had a lot of struggles last year and got things squared away. Ms. Corpening, are they still there?
No, Your Honor, they moved out. They did not give a notice as to move out, but I heard from his mother that they vacated and moved to California.
Oh
And then
my.
Sandra called me and left a message stating that we were able to take possession of the home, that they were not coming back.
Everybody's moving out of California.
Chris, is it, the property is vacant as we speak today?
Yes,
Okay.
it is. It's vacant right now.
The service was by attachment. So unfortunately, I can't do a default when I only have service by attachment. His mother's name is Aileen Bell. Is that who you talked to?
No, I don't know that she gave me. I just called the phone numbers that were on their applications to see what was going on, because they did have a lady that was living there for a short period of time. And she told me to call the mother. The mother called me back and she said she would get in touch with Sandra. I don't know her first name. I'm sorry. She just introduced herself as Mrs. Bell.
Okay. Don't intend to return. Well, essentially, that means we have to sit here for 12 minutes. If they show up, we can resolve this. If they don't, I'm going to have to set it, and it's a non-payment of rent. Yeah. I hate to go 30 days. I'm going to set it for 7 days. John, let's see what you've got coming up here. I don't want to drag you around the pea patch, but let's see if you've got some other dates coming up. John, I'm not seeing any other cases for you in the whole month of May. Probably some will develop. So I would go to May 10th.
Can I check real, what time are you talking?
Let's take a look. One 1:30.
Are you listening? Okay, May 10th, what does 1:30 work for?
I expect it would be a very brief hearing. Well, here's a phone number. Let's see.
1:30, it would just be like a 2-minute. May 10th at 1:30 would work, Your Honor.
All right, well, here is somebody. Maybe it's Hank. Good morning, can you hear me?
Yes.
Is this Sandra Bell?
No, this is Irene.
Irene, what case are you here on?
I think it's against Front Center.
Oh, Rent-A-Center case?
Yes.
All right, Irene, what's your name?
Irene Lopez.
All right, let me give you a name. You're a little early, but there's no harm in that. We're killing time anyway. All the Rent-A-Center cases are set for 10 o'clock. I'm going to put you in the waiting room, okay? Don't go away. I haven't forgotten about you, but it'll be about 20 minutes. I'll bring you back in. While we wait 9 more minutes for the clock to tick. Continue to May 10th at 1:30. I don't have you this afternoon either, so we're in pretty good shape. Ms. Corpening, Memory Lane's mobile home park was one of the first landlords to get on board with the eviction diversion last year when we first started. You were cooperative and you were good with the paperwork, and you got a lot of eviction diversion money for your company, and that's commendable. You helped keep a lot of people in there, including Mr. Bell, but apparently it still didn't work out for him.
No, he chose not to go back to work in his unemployment. I don't know what happened there, but he said he wasn't getting unemployment.
Well, I don't know that things will be any better in California.
No.
But anyway, I'm glad we can perhaps get some help for your company. Heather, did we forget something?
Yes, hold on.
What?
Oh, no, I have another one at 10.
Oh, you have a Rent-A-Center?
Yes.
Okay, I'll put you in the waiting room.
Okay.
All right, well, we've had passerbys stop in and say hello while we wait for a few minutes. Anyway, we're talking a lot of money right here.
Yes.
About $20,000 worth of arreared rent. That's nothing to sneeze at. So hopefully Bettina will make it all better.
Yeah, that would be great.
May I ask Tina a question?
Sure.
Where do I send Jerry's? Because I was not aware that I had to send anything for him. I didn't know he was trying to get help. I did ask him one day to get help, but he told me he wasn't sure if he was going to do it. So I wasn't sure he was doing it.
On his application, there was a landlord email listed, and there was an application sent to that email.
Okay,
and
I did get that email, and I sent a response back. Right now, my printer is down, so I cannot upload anything. And I sent back with, who do I send it to? Do I just send it to the fax at Keystone, and someone will get it?
Yes, you can attention it to me.
Okay. Attention Tina at the regular email.
Yes.
Fax number. Okay, thank you very much. You'll have that today.
Cool, thank you.
Yeah.
It is a non-payment of rent case, and theoretically, the law requires I set it for 30 days, but that's unfair to the landlord to just have the property vacant for that long. The next available date I have is the 10th, so we'll go with 10 days. And if they don't appear then, I'll issue the order by default. We have to wait 4 more minutes. You never know, Hank may call in from wherever he is.
Your Honor, are you getting any word from on high and what's going to happen with the CDC on July 1st?
Boy, I sure don't. Every time they did one of these, the last few, they would do them at the 11th hour. We had some that was supposed to end was supposed to end last year, September, then it was January 1st, then it was April 1st. I had some cases set for April 1st. There's one particular tenant the landlord's been trying to evict since last March. As far as I know, that tenant is still there. No, I don't. The hope is that we're turning the corner, and there's certainly a lot of jobs to be had.
If you go around Sturgis, there's work wanted signs almost everywhere, I think.
I was on vacation, and there's work wanted signs all over the place, but not just those. All the trailer factories are up and running now at full speed, and those jobs pay well. A lot of manufacturing jobs are looking for help, not to mention fast food and service industry jobs. So, no, I don't. At some point, I don't know. As long as the money continues, but as you know, it doesn't affect termination of tenancy or hazard conditions, but no, ask me on June 29th. The last order came out on March 22nd, but I didn't hear about it. March 22nd was a Monday. I don't think I heard about it until like Friday the 26th or even Monday the 29th. All right. It's 9:49. One more minute. Bettina, I think you're off the hook for the rest of the morning. I've got some cases at 1, non-payment of rent. I've only got 1 non-payment of rent at 1, Richmond and Howell. Although Amber Ferduce, do you remember that case? You weren't here yet. She's living in a house in Tamarack. And her stepfather moved out and left her there. She claims that they were going to accept payment from Keystone, but the landlord says no, we weren't, and she's not even on the lease. Keystone wasn't going to give her any help because she doesn't have a lease. So we'll be still struggling with that. All right, as far as Mr. and Mrs. Bell are concerned, we'll continue the matter to May 10th at 1:30. 8:30. And we got about a 10-minute break before the civil matters start at 10 o'clock. All right, anything further we need to do on this?
I'm good. Thank you, Chris.
Thank you,
Thank
John.
you.
Thank you, Your Honor.
Bettina, you're welcome to log back in at 11, but I'll need your help at 1, and then I think we'll be good to go.
All right. Thank you, Your Honor. See you at 11.
All right. All right. And I am dismissing the case of Ken McKinley and Kathy Spielman versus Mindy Price. I received a conditional order of dismissal from Attorney David Hughes. That is file number 21383LT. All right, I'm going to take this first batch of landlord-tenant cases out, shift gears into civil summary disposition mode, and rent-a-center cases. We have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases set for 10 o'clock. I'll be right back. You can stop the record for a moment. I'll leave the live feed on. Okay, we're gonna start lining up our customers for our 10 o'clock cases. Turn the recorder back on. Let's find out who this is. Good morning. Who am I speaking with?
This is Karina Van Treese.
All right, let me give you a name here. CORENAVANTREASE.
Yep.
Do you have the ability to do video?
Yeah. Do you want me to hang up and then call back?
Well, do you have to do that in order to turn the video on?
I have no idea.
All right, well, just stay where you are.
Okay.
All right, I've got another phone number I'm going to bring in. Good morning. Who am I speaking with?
Chase Deli.
All right, Mr. Deli, do you have the ability to do video?
I don't. My camera's still broken.
All right, stay where you are.
Sorry for the noise. If it's loud, I'm at work in the break room.
All right, better not be in here at all, I guess. All right, Mr. Deli, stay right where you are.
All right.
Bring in Irene Lopez. And,
Yes.
Ms. Lopez, can you hear me?
Yes.
And Heather Schrock. Bring in. Heather, welcome back.
Hello.
Let me give you a proper name. And we got Josh Ferris. All right, I'm not sure who this is. Good morning. What's your name?
Alyssa Ferris.
All right. There's several different people named Josh Ferris.
Yes, that's my husband. He's here, but he was in a really bad go-kart accident on March 27th, and he was on a ventilator for a while, so he's not able to, like, voice.
All right, well, he's there with you. Okay, thank you. Just stay right where you are. You got a lot going on at 10 o'clock.
You're fine. Thank you, Your Honor.
We got iPhone. Who am I speaking with?
Colleen Hawthorne.
Okay. Just a minute, I'm about to sneeze here. Good morning, Mr. Crew. Can you hear me?
Yeah, I can hear you.
All right, stay right where you are. Good morning, Mr. Pattison.
Good morning.
We've got about 10 cases lined up for you. I have, most of your clients are here. I have 2 summary disposition motions I'd like to do first. Then we'll just devote our time to the rent-a-center cases. And I believe those attorneys are logging in right now. Here's Attorney David Hoff, and here's Attorney Preston Nate.
Can we do the Joshua Ferris case first when it comes to my turn?
Yes.
We have a settlement. I told my wife and stuff, and we have an agreement in place on the record.
All right.
I'll come back in a few minutes then.
All right.
Thank you.
All right. Good morning. We've got a couple of summary disposition motions before we get into the rent-a-center cases. So the rest of you, just let you know, I'm Judge Middleton. I'm here at the court in Centerville. Some of you I can see, some I can't. For those of you that can't see me, I look really good. We're here on the YouTube and Zoom platform, and we are being recorded. Mr. Nate, let's take your case first, all right?
Okay, very good.
That would be LVNV Funding versus Karina Van Trees. Ms. Van Trees is here.
Okay.
Karina, can you hear me?
Yep.
Your name is not spelled like the song Karina, but
It isn't.
well, no, but same pronunciation. Mr.
Yep.
Preston Nate is here on behalf of LVNV Funding. This is a claim for $565.28. It's a pretty fat file for $528. They're also asking for cost, interest, and attorney fees. The judgment was filed and served on you sometime last year. You filed an answer on February 19th, essentially saying you were going to try to resolve it without going to court, and you wanted to pay $100 a month. Mr. Nate, what's the status here?
So we're actually okay with that, if that's still something. We did send Ms. Van Treese a proposed consent judgment for that $100. I don't know if she received that or not. It was kind of preemptive based on her answer. We didn't get that back, so we had to do what we needed to do, file a motion and keep the case moving. But if that's something she's still interested in, we're absolutely fine doing that. We can for a new consent judgment, something on the record, or however the court would like to do that, if that's something she's interested in.
All right. Well, let's add it up. Just a minute. 565.28 plus the filing fee of 35.
Yeah.
The summons fee of 42.72. Statutory attorney fee of $75.
We would actually forego the attorney fees, Your Honor, if we were entering into a consent or motion.
All right, very good. 35 plus 42.72 plus 77.72 plus 565.28 equals $643, which would take a little more than 6 months to pay this off. Ms. Van Treese, do you agree that you would pay the judgment in that amount at $100 per month?
Yes.
I'm going to show $100 per month starting June 1st.
Okay.
Let me look in here, Mr. Nate, and see if I have a judgment in the middle of all this pleadings I've got here.
Yeah, you probably don't. I know we sent you that default judgment a while ago, but that would have some different attorney fees on there. We're not gonna pursue.
All right, so could you send me a judgment in that amount under the 7-day rule as a consent?
Absolutely, yeah.
So can I just send the payment to where?
The payment will go to Mr. Nate's office. It'll be on the order that you get. He's with the law firm of Stinger and Stinger in Grand Rapids. Now this 7-day means he's going to send me an order that says you owe $643 payable at $100 per month starting June 1st. If that's what it says, you don't need to do anything. He'll simply enter the order. If he makes a mistake and puts the decimal point in the wrong spot and it says you owe $6,430, you have 7 days to object. That rarely, if ever, happens, but that's the example I use. Are you still at the M86 address in Ottawa?
Yep. Yeah, so will that come through the mail?
Yes, it will.
Okay.
And in Ottawa, you have to use the P.O. box. Is that correct?
Yes, yep. P.O. Box 18.
All right, Mr. Nate, we'll show it as a consent, $100 per month for 6.5 months. That'll get paid. Now, nothing prohibits you from sending more. And if you can't pay 100, send 80, send 50, send something each month to indicate you didn't forget. But if you pay it off, the matter will be completed. Do you have any questions?
Nope.
All right, you're free to go.
Right.
Thank you.
Thank you, Ms. Ventry. Appreciate it, Your Honor. Thank you.
All right. All right, that takes care of our first summary disposition motion, which is, as I said, quite thick for that amount of money. Our second one is file 21-12GC, and that is Portfolio Recovery Associates, Consumer Portfolio Services and Portfolio Recovery versus Colleen Carol Hathorn. Now they've got it spelled here, Hathrone. Let me make sure that's correct. How is your name spelled, Miss Hathorn?
Hathorne.
Yeah, they've got it spelled wrong. All pleadings have it as Hathrone.
For the plaintiff, Your Honor, I apologize. That's the way it appeared on the retail installment sales contract. That's what we used.
Well, Mr. David Hoff is here from his world headquarters in Cincinnati, Ohio, lowercase d, lowercase h, but we'll ask to correct this. This is a claim for $7,919. That's a lot of money. The defendant filed an answer indicating that she wanted to start to make payments as she got other debts paid off. Mr. Hoff, what's your position here?
Happy to. I'd be happy to make an agreement. I'd always rather do that than obtain a judgment otherwise. When I reviewed the answer, Your Honor, it said that Ms. Hathorn is making payments for 90 days to a different creditor starting in March. And I'd be tickled pink to wait until July. If we set up an agreed judgment, payments start in July when that one's paid off, that'd be fine. It looks like those previous payments are going to be $680 a month, which is egregious. I certainly would never want someone to pay that much. I'm thinking somewhere around $175 a month would probably be sufficient for us.
I could do that. On this one was a summons as well. So I had to do what they chose on the amount, and it's a lot.
Yeah,
All right,
that's,
well, let's calculate the amount again. We got 7,919.24, and we've got a filing fee of $42, a service fee $115 is that cost, $115 service. We can't discern the service fee. Do you have that handy?
I'm checking to see if we have a receipt from our process server on hand. I do not, Your Honor. I want to say it's $35, probably on the low side, but if I'm wrong, I'll. Oh, it looks like $65. I'm sorry, $65 is the check that we paid to the process server.
All right, $65, $75 statutory attorney fee.
We will forego the attorney fee.
Okay. 115 plus 65. Service is 180 in costs. 180 plus 7919.24 equals $8,099.24. All right, and you agree to pay that at $175 per month starting July 1st?
Yeah. We can go the end of the month. Give Miss Catherine a little more wiggle room into the month.
August 1st.
Sure.
Thank you.
All right, and you agree to those terms and conditions?
Yes.
All right, Mr. Hoff, would you send me a consent order to that effect under the 7-day rule?
I sure will, Your Honor.
Miss Hathorn.
Yes.
And I'll note correct spelling is Hathorn. As long as you pay $175 per month, they won't pursue any other collections. You can pay more if you win the lotto or you get a stimulus check or a big tax refund or something, you want to get this over sooner. But as long as you pay that amount, that will continue to keep this at bay.
Okay.
You're going to get in the mail a proposed judgment under the 7-day rule. If it agrees with what we said here, you don't need to do anything. It will simply enter. You'll make your payments to the address on the order at $175 per month starting August 1st and the first of the month thereafter. You understand?
Yes.
All right, do you have any questions?
No.
All right, you're free to go, ma'am. Thank you.
Thank you.
All right.
Thank you.
Very good. Thank you, Mr. Hoff. I'll see you next time. All right, that clears these other civil matters, and everything else is rent-a-center. Let me bring in another telephone number here and see who this is. Might be somebody ordering a pizza or something. Good morning. I've got you here by telephone. Who am I speaking with?
This is Irene Lopez. I was on the waiting room, but I accidentally hung up.
All right, Ms. Lopez, let me give you a name again. Same name. All right, we've got several rent-a-center cases. They're of different varieties. It's Mr. Richard Patterson's request that we take the Josh Ferris case first, so let me find that one. Here, this is file number 21190GC. It's entitled Rent a Center versus Joshua Ferris. Mr. Ferris is here with his wife. He was recently in an accident and has trouble speaking, so his wife was going to speak for him. Mr. Patterson, what's the status here?
Good morning, Judge. I've had the opportunity to talk with Ms. Ferris yesterday and today, and with her mother as well. And given the circumstances of Mr. Ferris's injury, etc., we reached an agreement we'd like the court to bless, and that is we're requesting an adjournment of today's hearing so as not to have a judgment entered based upon we have agreed to settle the entire matter for $2,200. And that payment arrangement is that they were to pay $1,000 today, which they have done. And then the balance of $1,200 will be paid at the rate of $200 per month, beginning May 15th, 2021. If he is late with any scheduled monthly payment by more than 5 days, then we are likely to renotice the matter for a hearing to enter a judgment. What we're trying to accomplish was fair to both parties by getting the money that we need and then saving the family from having a judgment entered. So, simply put, we're asking the court to adjourn today, and we will ask it that it be renoticed if we need to.
So we adjourn without date and
Correct.
plaintiff will notice if necessary.
Yes,
I'll
sir.
just go 6 months out.
That's exactly when they should have it paid off, so that works perfectly.
I'll adjourn this to December 14th. Well, no, December 18th at 10 o'clock.
You said 6 months, right?
Yeah.
That would appear to be around October.
Okay, let me try again.
Let's
June,
go
July,
roll.
August, September, November, December. May 15th to June 15th is 1. July is 2. August is 3. September is 4. October is 5 and November is 6. So we're both wrong.
Yeah, if they make their payments, starting May 15th, the last payment will be October 15th.
All right, well, let's continue this to October 16th. All right, it sounds like you've made a big dent on this with a $1,000 payment today. And you're gonna pay $200 per month starting May 15th. So
Yes.
we'll adjourn this. If paid in full, we'll dismiss.
I'll send Mr. Ferris a letter that contains this agreement in writing from us.
Okay.
All right, Mr. Ferris, I'm glad you're still here to deal with this. Mrs. Ferris, thank you for your help.
Yes, you're
Hopefully
welcome.
it's going to be resolved and you're good to go.
Thank you so much.
All right, do you have any questions?
Nope, I think that's it.
All right, thank you, you're good to go. I'll remove you from the feed here.
Thank you so much.
Mr. Pattison, let's do Ms. Schrock. I think she's got a small child in the car with her. Heather, can you hear me?
Yes, I can.
All
I
right,
don't have
now.
tomorrow, just waiting to go into work.
Oh, I thought I heard a baby crying or something, but all right. This is Rent a Center versus Heather Schrock. The file number is 2186-GC. Mr. Richard Pattison is here for the plaintiff. This case has got a lot of history. The defendant failed to appear. We had a bench warrant. She got arrested. She posted a bond of $500, which can be applied to the debt. And then this is also the time and date for a hearing regarding taking proofs on a default. So there's a lot going on here. You did one. No, you didn't. Mr. Pattison, what's your position here?
With regard to the bench court matter, I understand the court is going to award Rent-A-Center the $500 bond less the cost the court retains, which is fine.
Yes.
I'd like to present proofs for the entry of a judgment, and instead of having to schedule a separate discovery hearing, just have the opportunity to ask Ms. Schrock, where she employed.
I'm at Adapt.
She's at Adapt. All right, I'm going to apply the bond of $500 less costs to Rent-A-Center to apply to the debt. Mr. Malavi, can you hear me?
Yes.
Good morning, sir. This is your opportunity to provide some proof to support your claim for these damages. Would you raise your right hand?
Yes.
Swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
Your name is Ephraim Malavi?
Yes.
And you're the manager of the Rent-A-Center store in Sturgis?
Yes.
Mr. Pattison?
Thank you, Your Honor. Mr. Malavi, as the store manager, are you a keeper of the business records?
Yes.
And are you familiar with the accounts involving Heather Schrock?
Yes.
In the complaint we filed in this case, you've alleged that your store entered into 3 rental purchase agreements with her, one dated May 11, 2020, one July 30th, 2020, and one on September 9th, 2020 for the merchandise listed in the complaint. Is that true?
Yes.
And you've said that she has failed to make any payment of the merchandise since October 1st, 2020, with the next due date, October 17, 2020. Is that correct?
That is correct.
All right. So we have 3 agreements. With regard to the first agreement, the oldest one, that is May 11, 2020, that involves the 3-piece sectional. And I should say, what you're looking for, you've not recovered the property, is that correct?
That's correct.
All right. So are you seeking a money judgment for back rent, the fair market value of the property, together with court costs and attorney fees, or would you like to be able to recover some or all of the property at issue?
At this point, it makes it hard to understand if we should, because we don't know where the items are or if they're still around. So
you want a money judgment?
Judgment. Yeah, I would go for the money judgment.
Well, let's talk about the back rent in connection with that agreement. From the next due date until today's date is 27 weeks. And if you multiply that by the $29.99 per week rental rate for that agreement, the back rent due and owing is $809.73. Is that correct?
That is correct.
Could you give me that again?
When we applied, pardon me?
Is it
809.73?
890 or 809?
809.73.
Right. Okay.
When you apply the fair market value depreciation calculations in this case, you have a cash price of $1,990, and we subtract from that the product of 0.45 times the 50 weeks the contract's been in place times the weekly rental rate of $29.99. And when we do that, we come out with a depreciated value of $1,315.22. Would you agree?
Yes.
With regard to the July 30th, 2020 contract, again, the next due date was October 17, 2020, 27 weeks between then and now. And if you want to apply 27 weeks times the same rental rate of $29.99 per week for that merchandise, you have another $809.73. Is that correct?
Yes.
Now, when we calculate the fair market value using the depreciation formula, we have a cash price of $791.74 less the product of 0.45 times the 39 weeks the contract's been in place times the weekly rental rate, which gives us a fair market value of $265.42. Would you agree?
Yes.
Moving on to the third agreement. Again, we have 27 weeks from the.
What's the date of that one?
The third one?
Yes.
September 9, 2020.
Okay. All right, go ahead.
Thank you. So we calculate that back rent. We have again the 27 weeks times the weekly rental rate on that agreement of $49.99 per week for a total back rent of $1,349.73. Is that correct, sir?
Yes.
When we apply the depreciation formula in this contract, we have a cash price of $2,897.66 less the product of 0.45 times the 33 weeks the agreement's been in place times the weekly rental rate of $49.99 for a fair market value of $2,155.30. Do you agree?
Yes.
Now, when we add up the back rent on all three of the contracts, we come up with a total of $2,969.08. Is that right?
Yes.
We add up the three amounts representing the fair market value, we have $3,735.94. Is that correct?
Yes.
So when you add the unpaid rent to the fair market value figures, we come up with total damages of $6,705.13. Is that right?
Yes.
Now you're asking the court to award you your costs, which is comprised of a $150 filing fee, a $26.50 motion fee plus subpoena fee, plus service of process fees of $140.03. Is that correct?
That is correct.
So your total cost would then be $316.53. You agree with that?
Yes.
You're asking for the statutorily permitted attorney fee of $75 for a total money judgment of $7,096.66. Is that correct?
Yes.
May it please the court?
Less any of the bond that would be applied to that debt. Ms. Schrock, that was quite a big mouthful. They use these calculations each time, and they're supported by law. The formula for calculating the back rent and the formula for calculating fair market value. At this point, you keep the property. They're not asking for the return of the property. They're simply asking for money damages. What's your position?
I can make payments on it, but with moving out of the house and everything going on, when I stop paying it.
Yes. Well, I just had Ms. Schrock here on a landlord-tenant matter, and she's got some struggles with a separation and then reuniting and substantial back rent, and she's paying all the bills, and her boyfriend isn't doing much. And I'm just going to do the order, and then you guys can negotiate some sort of a payment plan. You may submit an order to that effect. Oh, I've got one.
You should have.
So I do. Yeah. So I've got 670513. Cost of $316.53. Attorney fee of 75 for a total of $7,009,666. Ms. Schrock is back at lot 160. This was done after trial.
It's lot 120.
Yeah, 120. If I said 160, I made a mistake. Ms. Schrock, my recommendation is that you call Mr. Patterson's office and discuss making some sort of payment plan here. Richard, I'm aware that she's got other struggles with her rent right now, and just trying to get that squared away. If it is, they may be in a position to set up a payment plan. All right, Ms. Schrock, do you have any questions?
No, sir.
All right, now you told us you're working at Adapt in Sturgis, and
yes.
Let's see if we got a phone number in here. Yes, we've got your phone number. Is the one that ends in 0374 correct?
No, it would be end in 0854 now.
0854?
Yes, the same first three numbers are the same, just 0854.
All right, Mr. Patterson, you got that?
I do.
All right, anything further on this one?
I would just like Ms. Schrock to know, I will send you a letter. You'll get it in a few days or so, where I invite you to contact me to discuss a payment plan. So we'll talk early next week, if that's okay.
Okay.
All right, Ms. Schrock, thank you. You're ready to go. I'll let you go.
Thank you.
All right, now, Mr. Salter has joined us. One of these is a discovery hearing, and that is Mr. Salter. No, Josh Salter. He's not here. We have David Salter. All right, we've got Chase Deli, Irene Lopez, and Brandon Crew are all here. We have a lot to do here. Let's call file 21174GC, Rent-A-Center versus Jezreel Tucker and Chase Deli, jointly and severally. Mr. Deli is here, Ms. Tucker is not. Mr. Patterson, what's the status here?
The status is we're here to present evidence in support of a judgment in which we're asking for back rent. We're asking for the fair market value of the property. It was all ruined, plus court costs and attorney fees.
All right, Mr. Deli, it's going to be similar to the last hearing. Mr. Malave, you're under oath still.
Yes, sir.
Mr. Patterson, you may acquire. Mr. Deli, is Jezreel with you?
No, she is at home sick right now.
All right.
She's got a really bad infection going on.
All right, Mr. Crew, I'm going to mute your microphone for now. You got too much background noise. All right, Mr. Patterson.
Thank you, Your Honor. Mr. Malavi, are you a keeper of the business records of your store?
Yes, I am.
And are you familiar with the accounts involving Jezreel Tucker and Chase Dell?
Yes.
We've alleged in a complaint filed in this case that you entered into 3 rental purchase agreements with them dated November 29, 2019, and 2 dated June 25, 2020. Is that correct?
Yes.
And that's for the merchandise that's listed in the complaint, true?
Yes.
We've alleged that they haven't made a single payment on any of the merchandise since October 30th, 2020, with the next payments due on November 7th, 2020. Is that correct?
Yes.
And as presented to the court, you're speaking of the back rent that's accumulated. You're asking for the fair market value of the property plus court costs and the attorney fee. Is that correct?
Yes.
With regard to the first contract of November 29, 19 for the Kate Brook queen bed and the queen mattress. 24 weeks have gone by since the next due date up until today's date. And if you multiply that 24 weeks times the $34.99 rental rate in that contract, your back rent is $839.76. Is that true?
Yes.
With regard to the market value that dies, to show that the market value as predicted, we
Richard, I'm losing you. Richard, I'm losing you. You're not at a very good signal.
You're losing me?
Yeah. Okay, go ahead.
Yeah, I hear you just fine. Okay. The formula we use is a cash price of $2,316.39 minus a product of 0.45 times the 74 weeks the contract's been in place times the weekly rental rate of $34.99 for a total fair market value of $1,151.22. Is that right?
Yes.
With regard to the first contract of June 25, 2020, we have 24 weeks times the weekly rental rate of $19.99. This is for the oversized swivel chair, which would make the unpaid or the back rent $479.76. Is that right?
Yes.
When we apply the fair market value depreciation formula to your case, it comes out to a total of 92 cents. Would you agree?
Yes.
I know it's unusual, but that's the way the numbers work. Okay. Moving on to the third agreement, recliner. Again, we have 4 weeks times $16.99 per week for a total of $407.76 for back rent. Is that right?
Yes.
When we apply the depreciation formula, we have a cash price of $679.60 minus the product of 0.45 times 44 weeks. The contract's been in place times the $16.99 per week rental rate for a fair market value of $343.19. Do you agree?
Yes.
What was the fair market value on the last one?
343.
No, the one before that, 72 cents is what it was?
92.
Oh.
92 cents.
92 cents.
480.68. $7.76 plus 343.19. All right, Mr. Patterson.
Mr. Malavi, when we add the three numbers that comprise the back rent, we come up with back rent of $1,726.98. Is that correct?
Yes.
When you add up the three numbers for the fair market values of the three agreements, we come up with a total of $1,495.33. Do you agree with that?
I think that's 3,145. Oh, I'm sorry. Go ahead. You were just adding you haven't got the whole total yet. All right, go ahead.
Yes, that's correct.
So, okay. What you're asking for, and you're giving up your right to the property. Is that correct? Because it's all messed up.
Yes.
Okay. So I'm looking at a different judgment form here. You're looking for a judgment comprised of the well, let's go to this first. You're seeking your court costs, which is comprised of the $150 filing fee, $33 for a motion fee and 2 subpoena fees, plus service of process costs of $178.62 for a total cost of $361.62. Is that correct?
Yes.
You're asking for the statutory attorney fee of $75. That's true, right?
Yes.
So the money judgment you're seeking is the sum of the back rent, fair market value, court costs, and attorney fees, which is the sum of the $1,726.98 the $1495.33, the $361.62, $75 for a total money judgment of $3,658.93. Is that correct?
Yes.
What was the total money damages without cost that you had?
Well, I have not added that because of the form my secretary chose to use. I can do it by hand here in a moment.
I did it differently than you did it. I did it by contract and you did it by fair market value or rent.
Yeah, so under amount of unpaid debt, I put in back rent, then under value of property, I put in the $1495.33 in the judgment that my office has supposedly sent you. So if your question is, how much is the back rent and the fair market value? I hope my math is right, where I say it's $3,222.31.
Read it again.
$3,222.31.
Plus 361.62.
Plus 75.
75. Let's add that.
I see where I could have put that 322 in that damages line. I failed to do so. Sorry.
$3,658.93.
Correct.
All right, Mr. Deli, that was again a big mouthful. You wanted to speak to that. What's your position?
I was just wondering, like, when the chair got damaged, we put in for maintenance on it, and nobody ever came and picked it up. So, like, they knew about the damage on the chair beforehand, and that's what I was just curious about.
How did it get damaged?
Me and my buddy, we picked it up and we were moving it, and my shoulder gave out, and I dropped it, and it broke a bracket.
Okay. Well, it's yours now. The damage was not their fault. It was yours. I'm not going to do a default. I'm just going to do it as to both of you. Mr. Pattison is going to send you a letter and invite you to contact him to discuss some sort of payment agreement. Are you working somewhere right now?
Yes, I received my job back that I lost during this whole COVID thing.
Where are you back to work at?
Basin material handling, BCI in Sturgis.
BCI, where, and that's in Sturgis? Is your address still?
31830, yes.
All right, Colon Road, Colon. Is Desiree with you or is she in Howe?
She has been staying at my house recently. She is sick. She has really bad infection in her body right now.
All right, well, I'm going to show this judgment in that amount, and Mr. Pattison will contact you and try to set up a payment plan. All right,
Judge, where should I send Desiree's letter?
Send it to his house.
You can send it to the same address. It'll be fine. Her dad doesn't normally give her mail right away.
Your address in Colon or the Howe address?
Yes, sir, my address.
Okay.
All right.
So again, I'll write him a letter, Your Honor, both of them to the same address, inviting them to give me a call to set up, if we can set up a payment arrangement without doing garnishments.
Very good.
Okay.
All right. Next we have Irene Lopez. Let me find this one. That's Salter.
Are we done? Your Honor?
Yes, you're good to go, Chase. I'll let you go. Thank you.
All right, thank you.
Irene Lopez is a discovery. We'll come to that in a bit. We got to finish this other business. So Irene, don't go away. Mr. Crew, wait a minute. No one's here on behalf of Jesse Martin. We'll set that one aside. Now I've got David Salter.
That's Josh Salter.
What? You, Josh? Well, they've got it spelled here as Josh Salter, S-U-L-T-E-R. Are you here on that case?
You got mine spelled wrong. Yes, sir.
Is that you? All right. So what's you're here as Josh Salter. All right.
Yep.
Okay, this is we did a bench warrant. The defendant got picked up on the bench warrant. I gave him a PR bond and let him out and set up for a discovery hearing today. So we're going to come to you in a minute, Mr. Salter, while we finish Mr. Crew, and then I'm going to swear you and Ms. Lopez and start that process. So Mr. Crew, would you unmute your microphone? This is file 21508GC, Rena Center versus Brandon Crew. This is a lot of stuff. Samsung something, an Apple iPhone, another Apple iPhone, some tools, PlayStation, and some other matters. This is a claim and delivery case. Mr. Pattison, what's the situation here?
Today is the time and date for the court to hear a motion for possession pending judgment, and I can present evidence in support of our motion should the court want it.
Mr. Crew, are you still out on Covey Road?
No.
That's still your address?
No.
All right. What's your address?
It's 69088 Texas Avenue, apartment 8, Sturgis, Michigan. It should have been with the courts.
It might be. Let's take a look. Yeah, that's what I've got.
Okay.
Rena Center wants their property back. What's your response?
My response, for one, I already gave the tools back. For one, I already gave the VR back. And they don't even know what they talking about, for one, because I just talked to the head guy, Chad, whatever his name is. He just told me 2,000. I just talked to Franco, and he told me I got to have it by the end of the week. That was an agreement of me and Chad. I told him by a week or two, I should have the 2,000. The only reason I wasn't able to pay because I kept going to jail, and one of the guys stole one of my business equipment, which put a default on me working. I've been in a center for almost 2 years, got almost $19,000 invested. So I'll be damned if I'm gonna sit there and just get all of my stuff ripped away after I paid just to buy everything already.
All right, let's break that down. When was the last payment made on this? Says here, defendant has failed to make a single payment on any of the merchandise since January 2021. Is that true?
I have no idea. I literally been in jail for these last 3 months. But either way, I talked to Chad earlier this week, and he told me that he'll drop down $2,000 to pay all cash. I told him I'll have him in a week or two. It hasn't even been a full week yet, so I don't even know why I'm in court.
The agreement you had with him was supposed to be in last week.
That's
what he
not
told
the
me.
agreement, because I talked to him last week on Friday. You wasn't there for the agreement. Plus, I have the text.
Stop. Only one person can speak at a time. So there appears to be some side deal going on here, Mr. Patterson. What do you know about this?
My understanding about it today is that the district manager, without my participation, tried to cut a deal with Mr. Crew, where I understand if he had paid the sum of $2,000, and I think Mr. Malavi will confirm last week, then the case would be settled and we would get rid of the case. But Mr. Crew, through no fault of Rent-A-Center, did not pay that amount of money. So therefore, Mr. Malavi has been told, go ahead and proceed with the case. Plus, we'd like to have our stuff back.
Mr. Crew, what's your position?
My position is, like I just said, not to disrespect anybody. I already paid too much on all of this stuff. And I already told the guy, me and him already talked, he's above Frank. He called me, I talked to him, and he told me he's gonna call me back. I haven't got a call back. I went to Rent-A-Center personally myself to see, bring back the tools and to bring back the VR. We made an agreement for me to pay.
So now, stop for a minute. Did you return the Porter cable tools?
Yes, and the VR. He said he was gonna.
What's a VR?
VR is like for PlayStation. So
it's packaged with the PlayStation.
No, this is what's going on right now. You and him has two different things, because he was gonna separate the VR and the PlayStation. That's what he told me. Plus, all of my calls are recorded, so I can send all of my info in. Plus, I have the texts. So you two need to work out y'all deals and get to me so I can make my payment. It is not over with, because you telling me something else and someone over you telling me something different. So how can that be over with?
All right.
And I came to you personally. I came to you and told you exactly what he said.
All right. Now, the fact that you went to jail isn't their problem.
It's not their problem.
You're in jail and no one's paying any of the rent on this stuff. So they were asking for the property back, and then they hold it pending further disposition in the matter, determining what happens. Now, you claim that you've returned the Porter cable tools.
You did.
And the VR. All right. Now,
okay. Richard, what's the VR again? What's the VR again, please?
Like
the VR, the PlayStation VR. It's packaged with the PlayStation 4.
It's not
packaged. Oh, that's the PlayStation 4 Pro?
Yes.
Okay.
It's not a Pro. I think it's a wrong label on it, but it's packaged with that.
So have you got those two things back?
I gave them the VR back because the PlayStation wasn't supposed to have been a part of my agreement, which I still have my agreement. Those weren't supposed to be packaged together. I already talked to Chad about it. You can see
the agreement is what have you returned?
I returned the VR and I returned the tools. The couch they didn't pick up because there was a scratch on the side of the couch. Chad already said
two things have been returned. Okay, so now we need the rest of it back. Judge?
The 2,000, I'm not finna pay. I already paid almost half of everything. I don't invested 19 grand in there. I can pay my 2,000. Like Chad.
Do you have another date coming up?
No, Chad never called me.
No, Mr. Patterson, do we have another Rent-A-Center date?
Off the top of my head, I don't know. Maybe Michelle would.
Yeah, I can look.
I'd rather make my payments.
I'm uncomfortable by this side deal, which you're not a part of, and Efren may or may not be a part of, but I don't know what it is.
His side deal ends tomorrow when his stuff gets charged off our system.
It doesn't end though. That's not what I was told.
Efren, Brandon, Mr. Malavi, you've been around long enough to know you don't just shout stuff out onto the record. Mr. Crew, I'll give you a chance to speak, but we're not around the kitchen table. We're actually in a court proceeding, live on YouTube, recorded on Zoom. So let's see if we can figure this out. I don't disbelieve what you're telling me, but I don't think your version and their version match. So I'm reluctant to grant the relief right now without knowing more about this other agreement. So I'm going to try to set it for a time that they're already here. That might not be possible.
There are no upcoming.
All right, we don't have any upcoming cases. I don't want to go very far, though. Mr. Pattison?
Yes.
Are you available? Let's see what we got here. Darn it. My calendars are so crowded. Next Friday, May 7th at 2:30.
I don't have my calendar, but I'll make it work.
I got a problem too, but that's a judicial conference day, but I'm gonna skip out to do this. May 10th at, excuse me, May 7th at 2:30. Who is this Chuck, or this person that made this other part of the deal?
His name is Chad.
That is the district manager for Franco Store and others.
All right, it'd be helpful to have him involved in this and sort this out. Mr. Crew, you're not to dissipate, damage, or move or destroy any of this property between now and next Friday.
I won't. I don't even. Yeah. My thing is, like I've been saying, I'll pay my things. I'll pay. I mean, that's not my problem, is to pay. I've been through a couple things I wasn't able to pay, but Franco been knowing me for the last 2 years. I have always paid my debt. Now, I'm not feeling comfortable returning anything. Me paying it's not a problem. I'm going to pay it. That's what I would like to do. I heard everyone else was able to pay their stuff that was way further past me. I should be able to pay mine as well. Everybody else getting deals and paying monthly payments.
Well, the problem with the other stuff is it was couches and stuff that was damaged. These are things that still have value, cell phones, electronic equipment. Now, they may agree to settle on an amount and you make payments, but they would rather have the property than $10 a month for 1,200 months. So we're going to continue this to next Friday at 2:30, which is a very inconvenient time for me, but I don't want to let this go too much farther. So we'll be back here by Zoom once again next Friday at 2:30. Mr. Crew, you're good to go. Thank you. All right. We've got Rent-A-Center versus Jesse Martin. Jesse Martin is not here. This is a claim and delivery action. What's the status here, Mr. Pattison?
Today is the time and date to present evidence in support of a judgment in this case, Your Honor.
All right. Mr. Malave?
Yes.
Mr. Pattison?
Thank you. Mr. Malave, you're the manager of the store and the keeper of the records. You're familiar with the Jesse Martin account?
Yes.
You filed a complaint on your behalf, which says that you entered into a rental purchase agreement with him on October 23, 2020 for the merchandise listed in the complaint, which is a StyTech gaming system. Is that correct?
Yes.
We've alleged that the last payment he made was on December 24th, 2020, and his next due date was December 26th, 2020. Is that correct?
Yes.
You have not recovered the game system, have you?
No.
I don't believe any of the property was recovered.
No. So what you're looking for here, as in the other cases, is back rent, fair market value, court costs, and attorney fees. Is that right?
Yes.
So with regard to the back rent, you have 17 weeks from the next due date until today's hearing date. You multiply that by the $39.99 per week rental rate, you come out with back rent of $679.83. Do you agree?
Yes. And
with regard to the fair market value of the product, using the depreciation formula, you have $1,008.95.63 minus a product of 0.45 and 25 weeks that's been in place times the $39.99 rental rates for a total fair market value of $1,445.75. Do you agree?
Yes.
When you add those,
give me that number again. 1445 or 1045?
1445.75.
All right.
When you add those two numbers together, you come up with total damages of $2,125.58. Would you agree?
Yes.
Now, you're asking for, shoot, I didn't write that in. You're asking to be awarded your court costs, which is comprised of $150 plus $26.50, which is a motion fee and a subpoena fee, plus a service of process fees of $145.12 for total cost of $321.67. Is that right?
Yes.
And then you're asking for the $75 attorney fee. Is that correct?
Yes.
So what I think I failed to do in my calculations, Judge, is include the court costs. So if I can have a moment.
I'll add 321.67 and 75 plus 321.67 plus 75 equals, I get 2,522.25 by default.
I got 4,647.
4,000.
Oh,
the
you know
rent
what?
is 679.
No. I'm wrong. I'm so sorry. Let me do it again. It's the 2125.58 plus 321.67 plus 75. So yeah, I have 2,522.25. Is that what you came up with?
Yes, it is.
All right. Thank you. I
both
don't like
wrong.
this particular judgment form.
All right, that one is a default. All right, now that leaves our two discovery cases. We've got Irene Lopez, who's been waiting patiently, and Josh Salter. My intention is to swear both of these people and then have you go into the breakout room with them one by one to conduct your discovery. Is that satisfactory?
Sure.
All right, Ms. Lopez, would you please raise your right hand, wherever you
Yes.
are? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
They're attempting to collect on this old judgment, which goes back to file 19498. I'm going to put you in a separate space where you can talk privately with Mr. Pattison about the ability to collect on this debt. You're under oath. He's entitled to ask things like your credit card number and bank account numbers and where you're working and that sort of thing. That's why we do it privately, so other people can't hear it. So I'm going to put you in the breakout room, and when you're done, he'll let you go. Mr. Pattison, then you check back in, and we'll do the same thing with Mr. Salter.
Okay, I will. Thank you.
And Efren, I guess you're off the hook. I'll let you go.
All right.
Oh, the problem is, Richard, hopefully she can join by phone. Mr. Salter, just stay right where you are. All right, Mr. Berlin, why don't you come back and join us?
All right.
Good morning, sir. Thank you.
Good morning.
Ms. Ferdos, would you unmute your mic?
Yes. Hi.
Good morning.
Good morning.
All right. This is the ongoing saga of the plaintiff trying to regain possession of the premises at 56486 Tamarack Lane, Three Rivers. Amber Ferdouse is here on her behalf, and Mr. Elliot Berlin is here on behalf of Swan Property Management, LLC. We've been here before. I'll repeat what was said on the previous record. This started out as a termination of tenancy by the tenant, who was Amber Ferdouse's stepfather. He attempted to remove her from the premises, but he didn't own the premises. He had a lease with Swan Property Management. He left some months ago, last fall or so, and Amber was in the property. Then Swan Property Management, who actually owns the property or manages it, filed this action to terminate the tenancy and get the property back. So they've been trying to get Ms. Ferdouse out of here probably since, I don't know, late last summer or in the fall. So the new case by Swan Properties was filed in February of 21. It was served on the defendant, and we had our first hearing on March 19th. Mr. Berlin was here and Ms. Ferdouse was here. There was a previous case which I mentioned, which was file 201778LT. Defendant attempted to file a CDC moratorium stay, but that doesn't apply to a termination of tenancy case. It applies to a non-payment of rent case. Defendant claimed, and I'm not saying this was not honest, but that she made some sort of an agreement with some agent of Swan Properties to do eviction diversion. However, she didn't have a lease, and they didn't want to execute a lease, and so she wasn't eligible for any eviction diversion. What she is right now essentially is a tenant at sufferance. She came in to live with someone else, they left her there. So the first hearing was March 19th. Then the second hearing was set for March 26th, and Ms. Ferdos was given a time on the record of 2:15, and there was a problem with that, so it got moved up to 1:40. So Mr. Berlin and I were here on March 26th. We made a record, and Ms. Ferdos wasn't present, so a default entered. Then at about 6 minutes after 2:06, she logged in, which is in time for what I told her on the 19th, but late for when the actual hearing was conducted. We sent her the notice, but because of the way her status is as a tenant at sufferance, I don't think she actually got the notice. Or she didn't open the mailbox until after the hearing, I think is what happened. So she said, well, wait a minute, I got defaulted, Judge, and you told me the wrong time. The bottom line is she didn't want to move. She was trying to work out some way to stay. So Ms. Ferdos, you sent me a very detailed and personal statement about your current circumstance. And that will be helpful for me on Monday when we deal with our other case. But we're in the same boat we're in. The plaintiff still wants you to move. You don't have a lease. You're not paying the rent, and you don't want to move. Mr. Berlin, does that sum up where you believe we are?
Yes, I agree with all of that.
Amber, what's your position here?
I believe, based on the many communications that I had with Mike Callis, that I should at least be protected by the CDC moratorium, because the whole time he was leading me to believe that as long as I came up with the money, that I would be allowed to stay here. And he had told me in detail in messages between me and him on emails that he believes that I would be approved based on my current circumstance. And he had been through it before, he said. He said he'd been through it. So the whole time I'm thinking, that I am being given permission to stay here, and I'm not coming up with any other, anything else, because I'm thinking that as long as I get approved, and the landlord who had been through it already with other tenants was telling me to actually apply for this. I mean, we got down to literally I was approved, and I even thought that the emails back and forth with us would be enough. The whole time, the fact that he was telling me that he believes I'd be approved and that he had been through it before, I thought once I got to that point and got approved, and all they needed for them was basically even like a letter stating that, that just basically like permission to live here, which is what I thought I had in my emails already, that they would get the money. And the fact that he had already given me permission to go through the eviction diversion program, I believe I should at least be protected under the CDC moratorium.
All right. And that's what you told me the last time, and would have told me the last time. But I told you on March 19th. So once they filed this action, you were on notice that they did want you to move. You don't have a lease. What somebody told you orally or in an email does not constitute a lease. It may have been something. At any rate, someone somewhere said, we don't want to do that. We simply want to get her out of this house. We never made an agreement with her. We didn't know she was until, and plus you knew before. Your stepfather tried to evict you last fall. And the only reason that you're still there is because you don't have anywhere to go. So you've been on notice that they wanted you out of there for months and months and months. All right, then this guy Kalis made some representations to you that maybe Keystone could help. So I understand why you said, well, okay, maybe I can work this out. But their position, as I understand it, as of the filing of this action and as of our first hearing on March 19th, is that they want you to move. Mr. Berlin, what's your position?
I disagree that Mr. Kalis represented to her that she had permission to stay in the unit. My understanding is she was encouraged to seek assistance if it was available to her. She then proceeded to forge my client's signature on a document that was filed in an application for aid, which upset my clients and certainly put them over the edge as to whether they wanted to even entertain the thought of entering into a written lease with her. There is no written lease. This is not an eviction for non-payment of rent. It's an eviction because she has no legal right to be at the property. And this has been going on for a very, very long time, and they're very frustrated and just want to be able to get their property back and re-rent it and put it to good economic use.
I have a writ of eviction that was submitted and it was entered by default. The defendant has asked to set the default aside, and in defense of her, she got confusing information as to what time the hearing was. I'm going to stay the execution of that writ of eviction for 10 days. Which would be the 10th of May. That's a Sunday. We'll make it the 11th of May. Amber, these hearings are set up to get resolution to cases where either people aren't paying the rent or the property manager just wants them out. Up until last summer, there was no emergency funding. People either paid the rent or they moved out. With a COVID circumstance, that came up, and we were able to help people stay in their housing. The defendant, or you make your position, plaintiff denies that the guy told you any of this or gave you permission to stay there. He said if you were eligible for help, apply for it. The problem is you're not eligible for help. You don't have a lease. They don't want a lease. And the purpose of this hearing is to give a drop dead date where you have to actually be out. So that date got extended by the mix-up with the notice of the time. And I'm giving you an additional 10 days from today. Mr. Berlin has submitted a writ of eviction and paid the fee for it. I'm going to hold it until May 11th. And then when I sign that writ of eviction, you either have to be gone or the sheriff comes and puts your stuff out on the street. The point of fact, no rent has been paid on this since I don't know when.
I would have loved to pay rent. I would have loved to give them something, but the whole time there definitely was an agreement, and I wish someone would just read the email.
All right, well, there isn't now. So let's forget all that. They started this hearing in March. You're not paying rent. You don't have a lease. Take all that stuff out of there. Let's say it happened, and let's say you paid your rent through February. Now but the biggest problem is you don't have a lease. You feel put upon, like, why is everybody doing this to me? They've been trying to get you out of there for almost a year. And you're living in a full house in a residential neighborhood without paying any rent. They're not even at this point asking for any money damages. They're simply trying to get you out. So you've been hanging on by your fingernails and you got 10 days. If you're not out, the sheriff's gonna come put your stuff out on the street.
Okay.
You do have 10 days to appeal this, but this is what this hearing was about. They followed the steps. They went to considerable expense to do this. There is no agreement. There is no emergency funding. There is no lease. You're a tenant at sufferance, and at some point you have to move. And that's May 11th. Now, I will see you on Monday. We'll talk about that on Monday.
Can you remind me again what the time of that is?
I believe it's 11 o'clock. Let me look. Maybe I got my day wrong. I thought it was Monday.
I thought it was in May. Yeah, it was in May.
It is in May. I thought it was next Monday, but I'm not seeing it. Well, let me just look it up under your name.
Thank you.
I already gave you one bad time. I'm going to give you another one. May 17th.
Okay.
At 11 a.m. So it's coming up. It's not next Monday. It's 2 weeks from next Monday. May 17th at 11.
Okay.
All right. In the meantime, you've got till May 11th to get out of this house. Just leave the keys there and let Swan Property Management know that you've left. If not,
okay.
Sergeant Morse will be there with a crew to put your stuff out on the curb, as bad as that sounds. All right, Mr. Berlin, anything further?
Nothing further. Thank you, Your Honor.
All right, thank you.
Thank you.
All right, we sure had a lot to do this morning. We're on the home stretch here. We have one discovery matter left, which is Rent-A-Center, Inc. versus Josh Salter, S-U-L-T-E-R. Is that you, sir?
Yeah, it's S-A-L-T-E-R, but yes, that's,
It's S-A-L-T-E-R?
yes, sir.
All right, again, they got your name spelled wrong, but,
Your Honor,
yes?
may I report that my discovery with Ms. Lopez went well? We've reached an agreement, and so can she be excused?
Yes. I'll bring her back in. She already hung up, I guess.
And for the record, the defendant's name in this case is S-A-L-T-E-R Salter.
Yes, that's correct. Not
Yeah,
S-U-L-T-E-R. Bettina, I'll see you at 1.
Thank you, Your Honor.
That girl needs some help finding placement, and I've been talking about her since last fall, but she's not eligible for your programming, so hopefully something.
You may be able to contact Keystone. We have other programs that may be able to help her.
Could you reach out to her?
Can you send me her contact information in the email?
Yeah, she did file an app. I'll give you that in an email here in just a minute, okay?
Okay, great, thank you.
All right, Mr. Salter, would you raise your right hand? You swear or affirm any testimony in this matter will be true to the best of your knowledge and belief?
I do.
All right, I'm going to put you in a separate room with Mr. Pattison. He can ask you questions. Now, you got picked up on the bench warrant for failing to appear for the discovery hearing. The discovery hearing was this that we're about to do right here. As I told you then, we don't have debtor's prison. You can't go to jail for not paying a debt. Where you got sideways is you didn't pay attention to a personally served subpoena compelling you to come to court. So I didn't want to just let you sit in jail indefinitely. That doesn't help get the debt paid. But I did give you 1 day in jail for contempt. So I'm going to put you in a breakout room, let you talk to Mr. Pattison. If the matter is resolved, you can just hang up. If you need further assistance, click back in.
Judge,
Yes?
Prior to having the hearing, I'm requesting, an award of an attorney fee of $250 for his having failed to appear. And this is my second time trying to accomplish the same thing.
Okay.
I'll award $250 for both hearings. It's not as bad as it was when you had to drive all the way down here. Here it's a virtual hearing on a day you were already here. But I will allow $250 for FTA for discovery. All right, I'm going to put you both in the breakout room.
Thank you, sir.
Thank you.
Well, amazingly, we finished everything we had to do today. This morning, we had quite a lot in there. I'm leaving the feed on for a minute in case they come back from the discovery hearing. All right, we have 1, 2, 3, 4, 5 more cases, including one difficult one, except for this afternoon. And that will complete a very long week.
Hello.
Hello.
I'd like to report we've had a successful discovery. We've made an agreement on a payment plan. And I'd ask that Mr. Salter be excused.
All right, very good. Mr. Salter, you're free to go on about your business. Thank you. All right, thank you, Mr. Patterson. We had a very busy day, but I'll see you next time.
Tell you what, just a moment of gossip. Have you heard about our Judge Tomac?
We're on the record here on YouTube.
Let me go off.
Yeah, just a minute. Let me complete this. That will complete our morning